Who's going to share the slides, Yasmine? Do you know? Are you going to
I'll
share?
share.
You will share the one I sent.
Yeah.
Okay.
So very good afternoon for everyone joining us today. We'll just let everyone trickle in before we kick off the webinar. All right, I think we'll start. So again, a very good afternoon for everyone joining us here today. My name is Mohammed Al-Musa, and I'm the program manager leading the Governance in Family Firms program, as well as the Governance in Tech program here at the Pearl Initiative. It is my honor and privilege to welcome you today to today's webinar on the enforceability of the family constitution in the UAE. We would like to thank our partners in today's discussion, EY, as well as our esteemed speakers, Yasmine Omari, who is a director at EY Private, as well as Fadi Hammadeh, who is the general counsel at Al-Futtaim. Before we launch into our discussion, I'd like to first start by introducing the Pearl Initiative. We are the Gulf region's business-led nonprofit organization set up by Gulf regional business leaders and the United Nations Office for Partnership in 2010 to support the growth of corporate governance, stewardship, transparency, and accountability in the private sector. We'd like to play a short video showcasing the Pearl Initiative and what it is that we do.
The youth are the future workforce. They are the future leaders for the businesses that fuel the growth of the region.
It is a privilege to be working with the Pearl Initiative in promoting higher governance standards, something for which there is a clear regional need for.
For our businesses, for our community, the more we engage the youth, the students at universities, the youth in their businesses, entrepreneurs, that is the area I think we should focus going forward.
You know, the Pearl Initiative started at a time where there was very little information about governance and very little even direction towards governance. And in the past 10 years, this has changed. The momentum is growing daily. And I would just say we need to continue what we're doing. We need to increase the way we are showing how transparency can be beneficial.
Thank you to all of our attendees for attending today's discussion. We have a fantastic webinar planned for you today with two wonderful and experienced speakers. I don't want to take up any more of their time, so it is my absolute honor and privilege to welcome today's speakers, Yasmine Omari, Director at EY Private, and Fadi Hammadeh, General Counsel at Al-Futtaim, thank for generously offering their time. We ask participants to please leave their questions in the Q&A section or the chat, and we will get to them towards the end of the session. Over to you, Fadi.
Yeah, good afternoon, everyone. My name is Fadi Hammadeh. A very quick intro. As Mohammed said, I'm the General Counsel of Al-Futtaim Group, 23 years in the region now. I've had the privilege of being part of this family business success and journey. I've contributed to the drafting of a number of legislations, workflow number 5 for 2018, federal family ownership law number 9 in Dubai, and then recently this family business law. So today I will be sharing with you some overviews and insights on this law, and then we will try and make it simple in a way that will also allow for reflection and questions. So basically, this sort of overview is structured around 4 questions. Why is there a need for a federal law? What's the point of having a new law right now? What is the laws? What is this new piece of legislation supposed to achieve? How would the objectives of family business continuity, and we will talk about that, be served by this new law? And who will be tasked with implementing it once it's fully in an implementable format? As we know, the law has entered into effect already last month on the 10th of Jan. And so pending issuance of some ministerial regulations and decisions to put it into practice, it's very much in an implementable form. So we will talk also about that. So why a law is necessary? Family businesses are not just a plutocracy that are there to support the interests or the narrow interests of the owners. There's the macro stakeholders economic objective of family businesses, which is really as a contributor of economic prosperity in the UAE and the larger GCC and globally, but also as a very important factor in social stability by being the largest recruiter. So often when we talk about family businesses, in our head, we sort of visualize the largest sort of families, but in reality, 90+% of all private sector businesses are more or less family businesses. And we will talk about how the legislator recognized that fact in the way the definition of family business has been expanded under this family business law to include even one-person companies, which could be really any company out there in the market. So family businesses are important. And next slide, please, Mohammed. Next, please. So failure to plan is planning to fail. It is a conscious decision that family businesses make. It's not something that will sort of fall upon them or sort of a vision that they will have at night. It's really succession planning is the outcome of very structured, hard, and passionate work that will sometimes last years, if not a generation. So the sooner a family business start the planning process, the better, because often it's a journey, it's not an event, and it takes time. Next. So why is succession planning particularly important in this part of the world? The issues that family businesses face globally are more or less the same, but in this region also we have some compounding circumstances that make it even more important, and that's why this law was issued for policymakers and legislators to address the particular issues of family businesses. Well, first, at the Family Business Council, GCC, we estimate that 80% plus of family businesses in the region, and UAE is no different, are preparing to pass the baton between the first and the second generation, that is the fathers and the sons or the daughters. and between the second and the third generation, that is the sons and the cousins generation. So we have plenty of transitions, but with no safety net to support their continuity. And often issues in family businesses arise in that critical moment. Like in any family businesses are no different than family, where the patriarchal or matriarchal figure suddenly disappear, leaving a gaping hole, and then bunch of heirs to agree amongst them in a sort of unstable emotional state of mind, who should do what and who should have what, and who should have decision over what. So these issues, if left unattended to, they're likely to give rise to conflict, and that's what this law seeks to try and alleviate. Also, our structures here, legal structures, meaning, are not optimal. Many family businesses continue to operate as sole partnerships or partnerships, sole establishments or partnerships, where the personality of the founders is sort of confounded with the personality of the legal personality of the company. And so once the founder expires, the company goes downhill with them. So it's that kind of confusion and lack of separation. Also, the concept of holding companies continue to be scarcely adopted, although the company law has allowed it as long back as 2015. We rarely see the concept of holding companies, which is a pillar of this law. It's very important to adopt a holding company. Also, another issue that family businesses are not aware of, naturally and understandably, is governance or corporate governance, which remains under UAE law the realm of larger listed institutions or banks. The private sector is not necessarily mandated or compelled to adopt sound governance systems, as we all know, because of lack of such mandatory provisions, which is something that this law sought to achieve. One of the constantly sort of concerning issues for family businesses is the question that all founders, next generation, and advisors ask themselves: whatever structure I create today may be challenged tomorrow on the basis that it's not Sharia compliant, especially if the family business is subject to fara'id or forced heirship rules, and that sort of concern. If I adopt a trust structure or foundation structure or even a waqf structure, how much am I falling foul with the fara'id, which we all know is public order? And this is, and in particular, Article 361 of the Person Status Law, which this law sought to address also in details. Lack of precedence. Often when we look at other countries like Japan or Europe, Belgium, Switzerland, France, we find family businesses that have been there for long generations. In Japan, the longest surviving family business was there for more than 1,000 years. They're very much lack of precedence here in this part of the world because of the relatively new nascent nature of our nations. UAE has gained, was formed in 1971, although family existed, pre-existed the nation, but most of them are, even the most ancient of them, and we find them in Oman, for instance, or in Saudi, or even in the UAE, they date back no more than 100 years at longest. So this lack of kind of longevity that will give rise to the need to have succession planning is also an issue. Limited education, that's why we're having this webinar today. Although we have legislations, and over the past 10, 15 years, the UAE has been at the forefront of legislating for this specific sphere. Very few family businesses are aware of the existence, or advises sometimes the existence and the use of these legislations, the wealth management legislations, and we will talk about that. Procrastination is a serious handicap, and we know that family businesses, unlike listed businesses, have this added complexity of the family circle interacting with the business and the management, and that family circle is emotional in nature, and often the emotional complexity of relationships that have started at a subconscious level between siblings long before they took over the business, kind of lended itself to the very nature of the family business. And if it's positive, it will be positive for the business, but if it's marred with rivalry and intergenerational struggle, then that will also impact negatively the family business. Procrastination is often an issue because founders consider planning as if they, succession planning as being tantamount to planning for their own funerals sometimes. You know, who likes to think about death and what will happen after? So often that decision is pushed and I'll do it tomorrow, I'll do it next month, but it's often also limited to the subject matter of today's discussion, which is drafting a constitution, which is an important thing, but it's just the beginning of the succession planning process. And Yasmine will talk about the challenges around enforceability and whether a constitution is really enough, which many family businesses believe it is, or whether it's really enough just to have a power of attorney for one of the next in kin to manage. And we all know what happened to power of attorneys when the founders die or the principal die, they naturally fall away. So by and large, there's a huge value at risk here. And it was estimated to be 1 trillion plus just within the largest family businesses, changing hands over it's happening as we speak. It's no more over the next few years. It is happening, and our court system in the UAE is rife with disputes between family businesses, either under the auspices of our court system or the concept of judicial committees that sort of put that value at risk, really, because of, as we will discuss, the risk of fragmentation, the risk of liquidation, the risk of dissipation of the family business. Next slide, please. So as we said, I have no doubt, I mean, 15 years ago when we started this journey, there was hardly anything. 2004, the IFC came with a trust law and that was about it. And it wasn't really geared towards succession of family businesses. It was there to provide a wealth management solution for businesses that wanted to set shop in the financial free zone. Some family businesses, and they're very few here in the UAE, have availed of that trust law. But we're not aware of it having become the go-to solution for succession planning. Then ADGN came and replicated what the IFC has done. They both created also legislations for foundations, single family office, which is by no means family office is a succession planning solution. It's just a structure to manage the private wealth of the family, and often there's a confusion between family offices and legislative solutions that enable ownership continuity, not just investment sort of control. Then a number of laws ensued. The chief amongst them was the Waqf law in Dubai, 2017, Waqf law in Sharjah, then the old seminal legislation at the federal level, the very interesting federal Waqf law number 5 for 2018, which for the first time in its Article 37 addressed the very specific issue of family business succession and highlighted the importance of the concept of Waqf Ahli or private Waqf or family Waqf. But to our mind, it hasn't been widely adopted, and we will talk about that in a second. Then also the family ownership law in Dubai number 9, which was based on the concept of Milkiyat al-Shuyur or the common ownership, really didn't take off also. And so we have seen that there are so many solutions. One, there's lack of awareness, lack of understanding how a family can benefit from them, and no two families are the same. So also framing this problem is very important in terms of choosing the solution. And that lack of awareness has not helped many family businesses to frame what is really their problems, what are they really seeking to achieve, and what piece of legislation may be helpful for them. And so came the need to have finally a sort of all-encompassing federal law. And if we can move to the next slide, please, we will talk about that. But what is that law? What has that law sought to achieve? The way this law was drafted is that rather than going through the normal legislative process of sort of sort of starting from top to bottom to top. We started from the problems, and we try to find solutions for that. So we almost identified like the most common source of litigations related to family businesses, not just in UAE and the region, but also globally. And we try to legislate for that. So if management paralysis following the death of the founder is an issue, we try to legislate for governance at the level of family businesses, and not just business, but also family governance. If distribution of dividends or the lack thereof, especially as a family business transition between first and second was an issue, then that was legislated for. If fear of forced heirship rules under Sharia was an issue, also that a solution was found. So the law is really was a combination of solutions to not fictionary problems, but problems that actually do exist in our court system and in globally in general. And the very reason why very few family businesses make it against the odds. And we all know that only 3 family businesses, global statistics, make it the second generation, and no more than 1 to the third generation, which is cousins. So why, and that why only very few family businesses make it through this perilous journey was the essence of it. And one of them is continuity of ownership on the demise of the founder. Often there's a tendency by the heirs, especially those who've not been part of the journey, to not understand the effort, the passion, the blood, and the sweat that went into building this family business. They may simply want to cash out. And there's nothing wrong with that desire. But then the question is, at what cost to the family business, to its cash position, to its liabilities to third parties, banks, suppliers, business partners, employees, to its economic unity, because 1 + 1, as consultants will tell you, equal 3 sometimes. And that's very true for family businesses, because what they love is to capture that synergistic existence, especially in our part of the world. Most family businesses are in retail, they're in construction, they're in real estate, and some of them are dabbling in financial sector. So this concept of diversity in family business, because they're organic and they're entrepreneurial and they're passionate and they want to address certain strategic need in the UAE, so they just sort of dabble with business sectors that are important for the economy. So often that kind of diversity is so important, not just for the family business, for the economy. And their synergistic existence is at risk of fragmentation in the absence of a succession planning that tells you what will happen to that economic unity once the founder expires, because then you'll have, instead of one owner, multiple owners or heirs, and each one will have his or her plan on what to do with this business or the other. I want to separate, I want to sell, I want to cash out, I want to list. So you get all this this plethora of aspirations that may impact the economic unity. The other that the law sought to achieve is the continuity, Mohammed, of management. The next slide. And this is one of the most prominent issues that face family businesses, is that, yeah, the founder dies and leave behind a number of heirs. And then some of them are capable, some of them are not. Some of them are willing to be part of the business, some of them are not. And then often you get this rivalry about who's going to be the CEO, who's going to be the CFO, who's going to be the chairman, who's going to be the vice chairman, who will call the shots. And then that kind of competition, if not regulated in advance, could lead to paralysis, and then often intervention by the court system and appointment of custodians, or and then leading the family business down the path of complacency and paralysis, which is something that often lead to disputes and ultimate demise of the family business. The third, what is keeping the family business, Muhammad, within the family. And this is not an objective that every family business seeks, but most family businesses consider it important. I'm building my family business for my family, and not necessarily me and my siblings or me or my few kids, but often family businesses have this longevity mindset, this generational kind of outlook, and they want to keep the family business within the family, and only in exceptional circumstances they're amenable to allow third parties to be in. Although some family businesses with entrepreneurial mindset. They want to build, to sell, private equity, or listed or whatever. So it's not always the case. That's why the law is optional. We'll talk about that in a second. And the last objective of the what is addressing this big elephant in the room, which is disputes of family businesses, disputes that are often much more complex than disputes of normal business because of that emotional dimension that we discussed, and the importance to have an effective and swift, quick resolution of family businesses before they fester, disputes before they fester. And many of them take, unfortunately, a criminal aspect to them. And we see criminal complaints being filed between siblings. And so many of these could have been sort of resolved or nipped in the bud well before they would have developed into full-fledged court disputes by conciliation and amicable resolution, which is a sort of hallmark of this region. It's a tribal community where we like to solve our disputes, but often the lack of institutional solutions around that lead for all these disputes to become public and festering in nature. Next slide, please. So now let's talk about the law. That menu of solutions that the law has provided, and then what are the main attributes? Well, one is federal, which is very important because we are a federation, and then the Constitution allowed several emirates, well, different emirates to legislate, and often we have this conflict of laws, and in family business space, there are plenty of legislations now. Many of them in Abu Dhabi, there are legislation in Sharjah, there is in Dubai. And then there are federal legislations like the trust, like the Waqf Trust Law, number 17 for 2022, I believe, and then the Waqf Law we discussed, and then this law. But it is important to have a federal law because you don't want to have a solution in Dubai that may not be relevant in another Emirates, or the other way around, because your assets are sitting somewhere else and you don't know whether the Emirate specific law will apply to these assets outside of the jurisdiction of a particular Emirate. So the federal nature of the law was important, although there were several initiatives at the time when this law has been drafted to do something similar in locally. Easy to understand, because for once, we wanted to, or the legislator wanted to provide families something they can understand. I mean, you don't need to be a sophisticated financial advisor or legal advisor to understand this law. It should be understood by, and I don't mean founders are not sophisticated, but they're not advisors, and they have this intuitive understanding of the business, and they need to be able to read this law and understand it as if it's addressed to them, because without which the legislator cannot instigate that desire that is very important, that is 80% of the way, to do something about it. That's the most important thing for founders, to say, yes, it is a problem, and I want to plan my own succession. I don't want to leave it to advisors or to Sharia courts or whatever courts later on. I want to solve this conundrum now before it festers. And so it has to be understood. And it's born out of the company law. It's not borrowed from some overseas jurisdiction or common law system. Nothing wrong with that. But for our local family businesses, it's born out of the womb of the company law. And at one point, there was a discussion on whether this should be part of the company law. And that debate ended with favoring having a standalone family business law for education purposes, for visibility purposes. And that was very important. Easy to access. If you go to a founder now or a next gen who have the all important task of convincing their fathers or their mothers of the important, who are often aging, and they set on their ways of doing something as drastic as having a trust or a foundation or a waqf as a solution. And there's nothing wrong with these structures, but good luck with that. Good luck trying to explain to your 80-year-old father that I have a solution for you. And what is that, son or daughter? Well, I'm going to separate your legal ownership from your beneficiary interest. It was like, what? And then who will own my assets? Well, I have this guy called a trustee. Who's that trustee? Well, it's a financial institution that is established somewhere. Like, it's a tough ask, and you wouldn't blame the founders for saying, well, let me think about it at best, and at worst, like, get the hell out of here. I mean, I don't want to do that. I don't want to give my ownership to somebody else. What about control? Are you seeking to take my assets away from me and then perhaps even approaching this subject with the concept of splitting ownership, which is what foundations, trusts, and waqf seek to do, may create a rift and sense of mistrust between generations. So it's not easy. So this law does not seek to do any of that. It's simple. Just change your articles of association and incorporate some of the solutions that we will talk about very quickly. I mean, don't freak out, dad or mom. It's business as usual. You, the owner, you, the manager, and you will continue until the last day, but we're preempting certain things in advance. And that's what this thing is, this whole thing is about, is that accessibility. And then implementing impenetrable and lasting solutions. And by that, you don't want a situation that you put in place to safeguard your family business for it to be challenged later on in a court of law for being non-Sharia compliant or for having expired, like family ownership law. Number 9 in Dubai only gives a 15 years old solution, and you have to renew it after that. And you need a resolution to do that. And so that you want something lasting, correct? Next, please. So the law is standalone. We talked about that. It's not mandatory, and it was one of the most contentious issues. Like, how could the law not be mandatory? Well, simply, you cannot have it as mandatory because no two family businesses are the same. It's like going to a restaurant and being forced to eat one thing. You don't like to do that. You want to have a la carte, and you want to choose. You may be a veggie, you may be vegan, you may be on keto diet. You want to have your own solution, and then some family businesses, we said, may not want to limit owners from selling to third parties. Others want to keep the family business within the family, which is an option. Some of them may want to reduce some of the sort of percentages required to make decisions. Some of them may want to have board of directors, which is allowed under this law, which is a tremendous advantage. But some of them may say, well, I'm too small to have a board of directors, but why should this be? Why should I have a constitution, for instance? It's too costly. I don't want to drop, or I don't want to hire. I'm just an SME. And then so that kind of multiplicity of optionality of the law is key to its accessibility. There's no one solution that fits all situations under this law. There are a number of solutions, and you pick what suits your requirements. There are very few provisions of the law that are nizam am, or public order, which I believe is one of its main attraction. That it's not a sentence, it's not an imprisonment. Also, you can opt out of it, and at any time with a 75% quorum, there is no majority. There is no sort of lifetime sentence here. Next slide, please. So what are the main sort of advantages, like really exciting, earth-shattering things that are bespoke, that are customized to benefit family businesses' continuity and sustainability across generation? Well, one, the law came with a very expanded definition of what a family is, beyond anything that was articulated in any previous legislation. For starter, spouses were included, laqarib bin nasab, which is very important because many laws do not recognize spouses as being part of the family, which naturally is wrong. Some spouses are closer to each other than brothers, and that's not wrong. Or they start as business partners, so the law recognized that. Also, what the law recognized, that many legislations almost instinctively refer to aqarib hatta daraja raba, or blood relatives until 4th degree, as if it's some kind of a rhyming concept. But 4th degree relatives, as we see in this chart, only limit solution to cousins generation, because as you can see, the way Sharia works is that son to father is 1, father to grandfather is 2, then grandfather to uncle or aunts is 3rd, and then going down to cousins 4. So you already exhausted the solutions and you limit them to 3rd generation. Else the objective is to extend solutions beyond 3rd generation. So we removed reference to 4th degree, and so now it's open. You could be 5th, 6th, or even 10th generation in the future, and you continue to avail of the benefit of this of the family business law if you wish to. Next slide, please. Also, the law expanded the definition of family businesses, although there is an element of family within the business, in the sense that at least 51% of ownership of the business has to be family oriented. But as we said earlier, the one person companies could apply to fall under the benefit from the provisions of this law, and that there is a tremendous advantage, because clearly a one person owned company, or as they call in French, société unipersonnelle, and the concept was borrowed from French law, by the way, in 2015. Well, there's no majority there, and that applies to many private sector, especially SME businesses out there that currently, and that was a push by the legislator to move from the concept of sole proprietorship into one person companies, benefiting from the limited liability structure. Clearly, family businesses are not a new legal structure, by the way. It doesn't add to what already exists in the company law. It's similar to one person company in a sense that is one person company is primarily an LLC, and it's similar to the holding company, which is primarily another legal form. So it's not a new legal form, and there are exclusions. Joint stock companies cannot benefit from this law because by definition, they are made to be traded. You cannot place restriction on the ability of shareholders to sell their shares. That's against the very existence and philosophy of listed companies, and also partnerships are excluded because by definition, by the legal definition, they expire with the expiry of the owners, and that's not the intention of this law. The intention was to provide continuity beyond the lifetime of the owner. So the two, but then by the same token, not only companies can benefit from this law, so entities that pre-exist this law, like only come after it's coming into effect, like trusts, like foundations, like onshore, offshore waqfs, would be allowed to benefit from the provisions of this law. Next slide, please. So this is an important slide. You're a family business, or you're an advised family business, and this law has come into effect. How do I benefit from it? What do I do next? So you either pre-existing company, a family business that exists. Well, naturally, the best advice we give: get everything organized under the auspices of a holding company. Tie all your assets, ownership directly or indirectly under a holding company. Go through that process. It's a bit painful, but it's necessary because you don't want to have multiple solutions across the group. And often family businesses here tend to take, even the smallest of them, they have this concept of multiple identity, multiple companies. Tie them under one company and apply the solution there. And that company either pre-exists the law or precede the law, or is created after it's coming into effect as an SPV to benefit from it. It could be one person company, as we said. It could be a financial free zone because the law does not exclude financial free zones. It could be an existing. It could be, as we said, waqf, trust, or foundation. And then from there on, the shareholders need to sit together and make a decision. And that decision is 51%. If we're talking about a trust, then it's the beneficiaries. If we're talking about waqf, it's al-mawquf lahum, also the beneficiary. So they need to come together and make that decision. And that percentage was deliberately dropped. In the previous iterations of this family business law, it was 75%. So the barrier was high. Was dropped at 51% to allow as many family businesses, if they so desire, to benefit from its provisions. Once the resolution is issued, then amend the association, which is very important. Company exists, then amend what the articles that exist to comply with the provisions of this law, or to mirror the provisions of this law. If it doesn't, then new articles would need to be drafted, and then prepare a constitution, which is an optional, and that's something that Yasmine will talk about later. It used to be mandatory under law. The law was, the initial drafts talked about mandatory constitution, that there is mandatory to be lodged with the family registry, but that was modified later on, and hopefully we'll have time to talk about that later. Then currently there is a ministerial resolution that talks exactly about this process that has not been issued by the Ministry of Economy yet, but it seeks to simplify the process. So an application electronically will be made, supported by documents that prove relationship between the partners, the issuance of resolution, and so on and so forth, out of association, and that would be lodged electronically. The competent authority, which is in Dubai's Dubai Economic Department, Tourism Authority Department, and then will vet these documents. Clearly, the articles would need to be notarized by notary public. Notary would not be required will have no authority to vet the contents of what the Constitution, for instance, or whatever. That it's not his role. His role is to authorize and validate the signature, authenticate the signature of the partners, and then DED will vet for authenticity, for correctness, for completeness, and then will submit the file to the Ministry of Economy. Ministry of Economy will have 20 days to approve it, and then once it's approved, a certificate of family business will be issued from the registry, which will be manned or woman by a registrar, and then a certificate of family business and a serial number will be allocated, which family business will be expected to use in all their correspondence along with the notation FB or family business. In short, that is the process. Next slide, please. What are the other benefits, tangible benefits? We know that 98% plus of probably less. The latest statistics from Ministry of Economy are not clear, but a few years ago it was 90% plus. I'm imagining it's much more now of businesses, incorporated companies here are limited liability companies. And there we have a major under the company law barrier, which is the number of partners who can own limited liability companies, which is 50. And often that number is easily breached because of nature of our family businesses. I mean, the patriarchal figures tend to marry more than one woman and they have children. And then often you get 50 when you reach the third generation. So what do you do beyond that? I mean, that was a general concern. And so this law came to alleviate that concern. So the law removed that cap that is already under the company law of 50, no more than 50. So now there is no cap, which is a very useful development. Next slide, please. We talked about continuity of ownership as a main what's or objective. And there the law sought to, the company law creates the concept of right of first refusal, that so shares should be offered to other partners if one partner needs to exit. If other partners do not wish to acquire these shares, then the partner under the company law can sell these shares to third parties. But that's a major concern in terms of allowing non-family members to be part of the family business, which, as we discussed, is an important consideration for family businesses. So this law sought to alleviate that concern by reimagining this process, saying, okay, you offer it to the other partners. If they don't want to buy, you cannot sell to third parties, unless with 75% approval of the shareholders. That percentage could be changed in the Articles of Association, so it could be lowered, but that approval is necessary. And then if they don't give approval, then you're stuck with the family business. And that's a decision that partners need to be aware of. There are options, there are exceptions to this. If other partners don't want to buy, but even if they do want to buy, you can transfer your shares as a partner of family business to your first degree relatives, i.e. parents, father, mother, or children, without offering these shares to the partners. You can ask the company, which is an important development under this law, that does not exist under the company law, to buy back your shares, up to 30% of the share capital of the company. It's also a very useful development. Keep them as treasury shares for 12 months before reducing the capital or selling them back to other partners or third parties. So that's a possibility and different exceptions that seek to alleviate that kind of sense of entrapment. Next, please. A very important development under this law that is, again, by no means shattering, but it's tremendous development for companies laws, not just in company law, not just in the UAE, but also anywhere else in the GCC, is the concept of classes of shares. Although the concept does exist currently in free financial free zones, borrowed from the English law, it does not exist on the company law, and it's of cardinal importance for family businesses. But why is it necessary, especially for family business classes of shares? Because it encourages patriarchal and matriarchal figures to plan their successions ahead of their own demise. Often the concern is that I am transferring ownership during my lifetime. Where would that leave me? You're putting an act in front of me. Once I transfer ownership to you, I'm going to be marginalized. And then that's tantamount to retirement for many family founders or partners. It's tantamount to an early death, and then nobody wants to that. And classes of shares allow them to plan for this succession in many different ways during their lifetime. Okay, son, daughter, I'm transferring ownership to you, but you don't have the right to vote. You get beneficiary interest, or you have half voting right, or 10th voting right. The law allowed for that. So it's almost like a probationary period. Even when we're looking at minors, I allow you to be an owner, but you only have dividends or half dividends. So classes of shares or fragment thereof is allowed. And it makes it also easier to allow for sale to third parties. So that kind of natural instinctive apprehension to allow for third parties, whether the individual institutions, to be part of a family business could be significantly alleviated with the concept class of shares, because I allow you to be in as a third party, but you simply have no right to vote. So the voting rights remain with the family members. That is seriously important. And currently, again, there's a ministerial decision being prepared, where it was a consultation committee, and comments were provided in this regard, and it is expected to be issued soon. Next slide, please. Dividends distribution, or the lack thereof, especially in the first generation, is one of the most relevant reasons for disputes between family members. As the platform of ownership expands, as we know, founders tend to reinvest any surplus of dividends or profits in the family business rather than distribute them as dividends, which is something that next generation may not be too keen on, especially for those family members that are not part of the family business. They're not working in the family business. They may just simply want to have dividends. And then the law fell short of mandating a distribution. There was a percentage before, but that was removed. But it emphasized the importance of distributing dividends, and it left it to the family business. So every family business to mandate that in the Articles of Association. So family business can simply preempt that issue by stating in the articles that at least 10% of profits should be distributed as dividend at the end of the year, of course, subject to cash, capital adequacy and liabilities and what have you. So, but that's a concept that is important. Next slide, please. Shares buyback. We discussed that, the importance of if a partner in the family business go bankrupt and there's a risk that shares could be sold in auction, public auction, to third parties, or foreclosed to bank, or if somebody wants to sell and no partner wants to buy, and there's treasury, there are funds sitting, there are reserves sitting with the company, and the company with 51% majority is amenable to buy these shares, then why not let the company buy them, even if it's a private company, and the companies these shares will have no voting rights per the law, but it will be like a transitionary period. And the suggestion, there's a ministerial decree also to detail this particular important aspect of family business lives. It is suggested that sort of holding right is limited to 12 months, because beyond that, it's kind of redundant for family business to buy their shares, keep them indefinitely with them. Next slide, please. I'm just going to accelerate because I'm mindful also of the time. So valuation is something that was discussed. It's a source of conflict. The next slide, please. Trimming the family tree, that's often squeeze out rights. Here, it's more of consensual right, but there's nothing that stops family businesses from mandating that in their Articles of Association, the ability to squeeze the minority out of the family business. Next slide, please. Then we'll quickly touch upon governance. This is the major element. So we talked about ownership of financials, incorporation, the governance. And so the law has had a clear provisions on that extends way beyond anything that is provided under the company law to regulate not just business governance in terms of the management, the importance of setting out managers in the Articles of Association, the concept of institutional management, but also of the ability of family business or private business or limited liability company to have a board of directors, which is something that is not currently clearly articulated in the company law. We talk about board of managers, and it's not the same. And along with the committees, the rules in terms of preference, rights and responsibilities, and the personal attributes, professional attributes required for members. Clearly, and then there was a very important addition in this law, that was born out of necessity. That is, in the important phase between the demise of the founder and the taking over the heirs, often there are all kinds of nefarious phenomena, and it takes sometimes, if not month, year, to transfer ownership between founders and heirs because of application to court system, appointing of administrators, and then succession planning process is inherently and notoriously a long process. And then in the interim, bank accounts are frozen, and then payments may become hindered and leading to insolvency. So the law sort of designated managers of the family businesses as the legal administrators of the succession of the assets. So they act very quickly to ensure orderly transition of ownership between hands, between generations, and that is a very important thing. Next, and I aim to finish within 5 minutes. Apology, Yasmine, I'm conscious that I've probably overstayed my welcome. We'll talk about family governance. Constitution was clearly articulated in this law. Yasmine will have time to talk about that. Different bodies, assembly, council, office, standard documentations, which now has been vested in the center that was recently established under the Chamber of Commerce to create standard documentation, being the Constitution, being the Art Association, and so on. So there are plenty of provisions there that address and recognize the importance of not simply separating family from business, but regulating that relationship, because it could also be beneficial, and then it provide the depth and strength to the family business that other businesses do not have. Next slide, please. Sharia compliance, very important. We talked about the apprehension of many family businesses. Article 361, a notoriously misunderstood article. It's not the article itself, is the way it was misinterpreted as prohibiting any transfer of assets during the lifetime of a family business owner, which may be perceived later on as to being in violation of forced heirship rules of fara'id. How and who, how should assets be distributed under Sharia, and who should get these assets? And any deviation from that, the risk for many family businesses could be seen as undermining the essence of any solution they could put in place. And this law sought to appease that by saying that any transaction that may happen relating to the assets of family business by way of sale, donation, grants, or will should not be considered as a violation of Sharia or Article 361 of Qanun Ahwal Shakhsiyya or Person Status Law, to the extent that it's perfected during the lifetime of the owner, and it does not take place during his death, illness, which is defined under the law as 12 months. And that was a tremendous achievement for this law, I would say. Next slide, please. Yes, and then dispute resolution very quickly. One of the most seminal addition, because that was like it remains a very chaotic process. And then the law has provided for the enactment or establishment, and there is currently a decree, Sheikh Emirate decree in Dubai, hopefully will be signed soon, setting out this judicial committee, and there will be a committee in every emirate, a judge presided over by a judge. There is a judicial committee, and also aided understanding the importance of having experts in family business affairs by financial sort of an aide who has expertise in financial affairs of family business, and one with legal and compliance and regulatory affairs to aid and support. And then this committee will be called into action if a mediation process at the behest of the family business leads to nothing or not been started, because the law allows for that process under the behest of the family council. If that doesn't lead to anything, then the judicial committee will come. And even that judicial committee, which decision has to be rendered within maximum 6 months, 3 + 3 extended, in line with, many of you are familiar with the concept of dispute adjudication board under FIDIC contracts. It's the same. The period was borrowed from that 6 month maximum, because anything more than that will not be beneficial to the family business harmony and continuity. So there is a need to fast track these disputes, and so that therein the importance. But even that judicial committee is not mandatory. That gives you an idea of how flexible this law is, because any other association, family business who may not want to submit their disputes to the judicial committee may opt for arbitration, for instance, a private justice, or they can opt for, if they're comfortable with if they establish in the IFC or DGM with the courts of financial free zones, they can refer the disputes to the financial free zones court. So that is also allowed under the law. Next slide, please. And we're finishing soon. Expiry, this will require a 75% resolution by family members to delist, and then the family business will go back to the situation they were in before they became a family business. Or if the ownership is less than 51% family members, then de facto they will revert back. Next slide, please. There will be incentives and benefits proposed by the cabinets. They're not yet decided. Some of them may be taxation, tax holidays, payment of reduction of payment of fees, charges, licensing, what have you, quotas. So that's something that is currently being reviewed to entice and drive family business to benefit from this wonderful piece of legislation. Next slide, please. And then going forward, we discussed the law has come into effect, the decree by law. There are 5 complementary resolutions that are currently being put in place, and hopefully there is a serious desire by the Ministry of Commerce and the federal legislature to put this law into effect as soon as possible, because we're not preempting a problem that is going to happen in the future. As we speak live, we have problems and situations that many of you are aware of, patriarchal figures who are no more, shambolic transition process, and many are in the pipeline. So there's a need to activate and put into effect ASAP. There is no time to wait for implementation regulations, which is often the time. And that's why the law was issued as a decree by law. It wasn't a qanun, it wasn't a law. And as we know, laws go through national assemblies. It was a decree by law because it was a desire by the political leadership of the country of the need to issue this by the president of the UAE, which was the case here, and not wait through the usual sort of parliamentarian process that for instance, the commercial agency law has gone through. I believe this is the last slide. Mohammed, is there anything else? Who will do this? Owners, next gen executives, board advisors. I think that's commonsensical. Next slide. I think it's, thank you very much. Thank you.
Thank you,
Thank
Fadi.
you so much.
Thanks, Mohammed. Sorry, I was just going to butt in to say thank you. We were going to do a section now on the provisions of the family constitution and the what, how, and why, but I'm conscious that we've used up our time, but we did not want to cut Fadi off. For those that may not already know him, you probably do. He has been a key proponent in, the drafting, the creation of these laws, and the influencing of the legal environment. So we have a very credible and trusted source here, so we wanted to take advantage of that. So thank you, Fadi. I have in the meantime discussed with Mohammed, we can do the same session covering the what, how, and why of the family constitution, same time next week, next Wednesday, the 1st of March. And in the meantime, if there's anything that we can support you with or address, please do send us your queries. Sorry if you wanted to join for that session in particular, but I'm sure that you found the earlier session valuable too.
Yeah, Yasmine, I'm available for any questions. If anyone wants to stay behind for 5-10 minutes and answering questions that you may want to ask or Mohammed wants to ask, I'm also available. It's your call.
Thanks, Fadi.
Thank you so much, Fadi and Yasmine. And yes, we will share the webinar link for next week's session with Yasmine. Thank you for generously offering your time. It will be on the what, how, and why of family constitutions. And of course, thank you so much to Fadi for what was a wonderful session today. I wish when I was doing my dissertation, we had these amazing open and conversations around family businesses. We did have one question in the chat from Stephen Reese, which is the only way to deviate from Sharia succession law for the patriarch to gift in lifetime. If the constitution details a different path, does this take a precedence?
The answer to this, even a gift of what we're talking about, family businesses that are subject to Sharia, only a gift may not be enough if one, it's not perfected. So it's like we call it shart waqif. If its entry into effect is conditional upon the demise of the person who's gifting, who's making the gift, or if it takes place during the what we call the death illness, which is 12 months prior to the death of the family business partner or founder. So, but generally, yes, that's the way. And many family businesses in the region, like Rajihi, for instance, a prime example, have done that. And there are a few family businesses here who gifted the patriarchal figure, gifted its family business, also during their lifetime. But another solution, if that is the question, is to have a waqf in place. And the waqf is a beautiful structure, and is born out of something that many family businesses here are comfortable with. It's a construct that they're familiar with. Waqf Ali allows for that. And it goes one step further, because a waqf can be created, but its entry during the lifetime of the founder, its entry into effect can wait until its demise. So the founder could be the settler and the beneficiary, or the waqif al-mawquf lahu, and there will be a nazir who could be the family business manager, and then it continue to be the owner, and then the ownership or the beneficial interest of it will move to the muntafi'in or al-mawquf lahum, or the beneficiaries upon his demise. And there, an added advantage is that the family business does not need then to comply with what is considered to be Sharia compliant ways of distributing assets, boys versus girls, at what percentage, and who should inherit what. And so then the founder can distribute its ownership on the basis of meritocracy, who has the skill, who has the will to take over. And that's something that a waqf could help with. Of course, trust and foundations are very similar if the family is not Muslim.
Thank you, Fadi. I think if anyone else has any questions, I would encourage you to very quickly enter it into the chat or the Q&A. I think we have one more. I'll take this as the last one, just so that we don't eat up too much of Fadi's time. So Hanan Abbas asks, there's a general understanding the family business will not survive over 4 generations. The law is to help the family business to operate professionally. Is the governance issue well detailed and covered in the law?
Very good question. It is, and I encourage that everybody to read the law. There are ample provisions there that, as we said, address the 2 dimensions of governance, that is the business and the family, and the overlay, the interplay between these two, how they interact, the family and the management. And so, yes, absolutely, that's an important element of this law. It's a fundamental aspect of succession. And clearly, the law only sets the minimum required to be adopted, but families can go far and beyond in their constitution to detail more things related to employment, to education, to dividends, to dispute resolution, to the value system that I'm sure Yasmine will talk amply about in her next webinar. But this is just the basic requirements, and the law was cognizant of the fact. And often also the smaller family businesses that 80% of our economy rely on. The private sector is not just made of large family businesses. It's the SMEs also that often fall through the cracks, that require a certain level of sound governance. And then the importance of having these pre-existing models well articulated and documented and standardized under the auspices of this law would go a long way in encouraging these SMEs to adopt sound governance models. They allow, one, for their stability and continuity, but also for their credibility, because it would work to their advantage, financial credibility, employees' credibility, as a business that would stand the test of generational transition, which is key element of continuity.
Yeah, just
thank you so much, Fadi. Oh, sorry, please go ahead.
Just to add on Fadi's point of the governance. So the interesting thing with the law is that it's opt-in, in the sense that it's hard for the government to legislate the private sphere in the sense that it's a privately held company. So whereas obviously on listed companies, you can mandate and stipulate certain requirements, it's not as easy or realistic to do for private companies. But that is where governance frameworks come in. And it's not just about, the drafting of a family constitution and putting in place the constitution, but it's about drawing alignment among the family and the shareholders with respect to the future vision and ambition of the family business, but also implementing and effecting the necessary platforms, the necessary decision-making bodies, i.e. the shareholders assembly, the board of directors, any other bodies that may be required, and also making sure that there's a communication among those bodies, because no matter what you prescribe in the family constitution, as long as it's not necessarily lived and it's not implemented and practiced, there is little value to that. So the law, as Fadi stated, adds kind of guidance points, the bare minimum, but there's a lot that can be built up upon to put in place the most robust framework to promote sustainability for family business and future generations.
All right, Mohammed, Yasmine, I'm afraid I have to dash right now because I have a meeting, but thank you for inviting me, and I hope this was useful and beneficial to the audience.
Thank you. It's useful to me.
Thank you so much, Fadi.
Thank you.
Bye-bye.
Good luck to everyone. Thank you. Okay. Sorry about this.
Thank you to all of our participants as well, and to our session partner EY and Yasmine and Fadi for generously offering their time. The Pearl Initiative regularly holds these types of discussions, and I would encourage you to check our website for more information on those sessions that we do. We will be following this up with a recorded video of this session and an invitation to next week's session on the 1st of March. Thank you very much for joining us today, and hope you have a wonderful day ahead of you.